Excellent. Well, good afternoon, everyone. Thank you for joining. My name is David Yulian. I'm a partner in the Boston office of Vicente LLP. This afternoon, I'm joined here also by my colleague Phil Silverman, and this afternoon we're hosting this webinar that's going to focus on Rhode Island cannabis retail licensing with a primary focus on local real estate and local zoning considerations. So we're just going to give it maybe 30 seconds, let additional people join, and then we'll get started. All right, so I think we can go ahead and get started. So again, thanks for everyone for joining. We're going to go ahead and get started with this webinar on Rhode Island cannabis retail licensing. So next slide, please. So we're from Vicente LLP. We're a national law firm that focuses on cannabis and psychedelics. We were founded in 2010, and we help clients navigate laws and regulations, help their businesses grow, and shape public policy to advance legal cannabis, hemp, and psychedelic sectors across the country and across the globe. We're a national law firm, and we have offices in a variety of states, including Massachusetts, California, New York, and New Jersey. And we've worked on licensing applications in just about every jurisdiction where there is a legal cannabis program. We offer a variety of services, including federal, state, and local licensing, corporate and transactional work, market research, policy drafting, real estate litigation, and government relations, among other things. Next slide. All right, so today we're going to have myself and my colleague Phil Silverman. Some of you may have seen my colleagues Meg Nash and Jeremy Shaw. Were going to join. Unfortunately, they had a conflict, so you're stuck with Phil and I today. But as I mentioned, I'm a partner in the Boston office of Vicente. I've been in the cannabis industry since 2016 and focused primarily on regulatory licensing, compliance, local permitting in cannabis, hemp, and the psychedelics industries. And then I'll let Phil introduce himself. So go ahead, Phil.
Sure. Hi, I'm Phil Silverman. I'm a partner in the Boston office as well. A little bit older than David. I started out my career working for about 30 years as a bankruptcy and insolvency lawyer in Massachusetts. And then about 10, 12 years ago, I got into the cannabis space. I was actually chief operations officer of a Massachusetts licensed cannabis business. But then I decided to get back into the legal space about 10 years ago with Vicente. And I do state licensing work, and I do quite a bit of land use work in the marijuana space. And so I've been doing this in Massachusetts, Connecticut, and Rhode Island really for the last 10 years. I think at last count, I've obtained over 150 permits and approvals for marijuana businesses. So, like I said, I've got some experience here. Just, a quick take on everything you're going to hear today. We're going to walk you through, quite a few rules and some regulations. And, I think this is very promising for Rhode Island in the sense that there's a limited number of licenses. Unlike Massachusetts, this is strictly limited, and I think that's going to make it a much more viable business environment for these companies. That said, it is kind of unique. There are obviously medical and adult use businesses in Rhode Island already, not a lot of them, but a couple of them. And so this isn't completely unfamiliar to the state. On the other hand, there's still quite a few cities and towns that have not actually experienced having a marijuana retail store within their borders. And so this is new. This is completely new to them. And so a lot of these boards that are going to be doing your municipal approvals, this is going to be completely new. They're not going to understand it, and they're going to need a lot of education in order to understand why this is not something to be feared, something that can fit in with their community. And we've been very successful at doing that over the years, and I'm sure we'll have great success also in Rhode Island. We've got a solid track record. You'll also probably see, as I've experienced, quite a few residents that will show up at these municipal meetings. I've been told on numerous occasions that I'm destroying the fabric of the community by what I'm asking them to do. I don't believe that to be the case, and I think we've had good luck, notwithstanding some residents who aren't or are at times a little grumpy about this. We've managed to get by and get our clients approved. So that's just a little background about me and some 2 cents on where I think we're going in Rhode Island. Go ahead, David.
All right, thanks, Phil. Next slide, please. So just an overview of what we're going to cover today. We'll provide a high-level overview of the state's cannabis program, a little bit about the current landscape, and how many licenses there are currently, as well as how many are going to be available in the coming months. We'll provide a little bit of an overview of the retail license application process, some of the documentation and information you'll need to provide, as well as some tips and best practices for navigating that. And then we'll get into more of the primary focus of this presentation, which will really focus on municipal restrictions and zoning requirements for retail cannabis businesses specifically. A big component of that is obtaining a property and having control of a site that you can have approved with a permit for your facility. And then we'll follow up with the end with just a little bit about the current social equity applicant certification process. And then hopefully we'll have some time to try to answer some of your questions. So a lot to cover, and we'll just jump right into it. So next slide, please. All right, overview of the Rhode Island Cannabis Program. Next slide. So cannabis has been around legally in Rhode Island for quite a while. The state legalized medical cannabis in 2006. And the first medical compassion centers, is what they're called in Rhode Island, commenced retail operations in April of 2013. And then for a while, it was sort of just medical, but then in 2022, the state passed the Rhode Island Cannabis Act, which legalized adult use cannabis and also established the new agency called the Cannabis Control Commission. At that time, the existing medical compassion centers were allowed to obtain hybrid retail licenses, which would allow them to sell both medical and adult use. That started in December of 2022. So the only businesses that to date have been able to sell adult use cannabis to individuals 21 and over are the existing medical cannabis operators who obtain that hybrid retail license. So this idea of the upcoming licensing round would be to distribute adult use only retail licenses that would not have a medical component also associated with it. Very recently in May, authority over both the medical and the adult use cannabis program transferred over from the Department of Business Regulations Office of Cannabis Regulation to the new Cannabis Control Commission. So you may have seen regulations and information from the DBR and the OCR for going back for years, but now the only game in town is the CCC. And currently in the state, there are 7 licensed compassion centers and quite a few, approximately 60 licensed cultivators. So a pretty limited market so far. But with the number of licensed cultivators, I just wanted to point out that there is a statutory moratorium, which means no new cultivator licenses are going to be issued to any businesses for at least a period of 2 years. So right now, we're really just focusing on expanding the retail market in Rhode Island. Next slide. All right, so a little bit about the new retail licensing opportunity. There are going to be a total of 24 retail licenses available, and those will be spread out across 6 different geographic zones that the state has divided up into 6 different zones. Within each zone, there will be a maximum of 4 licenses. And of those 4 licenses in each zone, 2 will be reserved for general applicants, 1 will be reserved for social equity, certified social equity applicants, and 1 will be reserved for an entity that qualifies as a worker cooperative. which is essentially a business that is made up of individuals who commit to, workers' cooperative and democratic principles. So very kind of a unique license type there. But those are the four types of licenses in each zone that will be issued. Only people will only be able to apply for one license in each zone. So you will be able to submit a license application for a retail facility in multiple zones. But if you're ultimately selected for more than one, you'll have to choose which location you would like to have. So this is goes to say that you really want to think about where you want to be. It's not the type of systems that you may have seen in other states where you sort of apply and then you can kind of figure out where you want to be after that. You really need to do your due diligence now and get a sense of what part of the state you really want to be in. So when applicants submit a complete license application and it's deemed to be qualified by the CCC, then there will be a lottery. So there'll be a kind of a random drawing to decide who is selected to operate in those specific types of license types in those specific geographic regions. So we call this a sort of a hybrid licensing process because it's merit-based in the sense that you'll need to submit a complete license application that qualifies, but once you are deemed to qualify, you'll be entered into a lottery, and then it's just a matter of chance if you're ultimately selected. Next slide, please. So this map lays out the different geographic zones, and this is sort of set by the statute, and it's not something that really can be changed by the CCC. So you'll see them laid out here as well as the municipalities within each zone. So this gives you a sense of the different areas where you can apply. And I just wanted to point out that there are some municipalities that have voted to prohibit retail cannabis within the city. So you may see that there are some that aren't going to be allowed to locate a facility in that particular municipality. So you should definitely make sure that if you're looking at a particular property, it's in a municipality that actually will allow an adult use retail cannabis business to operate there, because there are a handful that will not allow these. Next slide, please. Okay, so this provides a very high-level overview of the types of information and documentation that the commission is going to require as part of your license application. So you'll see they want information about your property, who owns it, whether you're leasing it or you purchased it or you own it. They want to make sure it's not located too close to any schools. You'll provide floor and site plans prepared by a professional architect or engineer. And then one major part of this, which we'll get into later, is this final zoning approval. So as we understand it right now, this will require you to actually go to your local municipality and obtain final zoning approvals for your proposed use at a particular property, which is definitely an intensive type of request. But again, we'll get into that a little bit later. Moving over to business information, pretty standard types of documentation and information about the actual entity that will be the license holding entity. So you'll have to, incorporate an LLC or a corporation in Rhode Island and provide, sort of basic corporate documentation to prove that the company that is applying to hold the license is in good standing and actually exists. And related to that, again, more corporate governance documentation they'll want to see, a full disclosure of all your owners and your individuals who will be in control of the entity. And this is particularly important because there is a residency requirement. So this is something that we've seen more and more in different jurisdictions, but in order to qualify, you are going to have your company majority owned 51% by Rhode Island residents. If you're sort of applying, you're interested, you're out of state, this would be a good time to try to make some introductions to some Rhode Island residents that you may be able to partner with to satisfy that majority ownership by Rhode Island residency requirements. And then sort of standard disclosures about financial interests, any prohibited interests, any involvement with other cannabis licenses in other jurisdictions, and any agreements if you have, for example, a management company that is going to come in and actually operate the business. These are the types of documents and information that will need to be disclosed as part of your license application. Next slide. All right, so additional documentation you'll need to provide, a business plan that lays out your experience, your sources of funding, your compliance plan, a detailed timeline for initiating operations, and then a lot of operational plans that they want to see. So security and safety plan, which would involve details about your alarms and camera systems. So this is sort of the thing that you would want to engage a professional security company to help prepare your plans and make sure that they satisfy the regulatory requirements for security. Your details on cash management and payments, banking plans, operations procedures. And again, it's important that these plans be detailed and are compliant with the regulatory requirements. So there are a number of operational regulatory requirements for cannabis businesses, and you would certainly want to make sure that any operations plan you put together is compliant with those regulatory requirements. And again, this is a lottery, so you need to provide plans that are compliant and sufficient to be able to be deemed qualified and get into the lottery. So these are an important part of your overall application. And then lastly, you have to indicate which geographic zone you're looking to apply for. As we mentioned those 6 different geographic zones in the prior slide. And then the application fee is $7,500, although that fee is waived if you are a social equity applicant. So suffice to say, it's quite a bit of information and documents you'll need to put together. I certainly recommend working with some professionals, whether it's financial advisors or engineers or architects, security, certainly legal, to make sure you put together a complete and detailed enough application that will allow you to actually get into the lottery. Next slide, please. All right, so just an estimated timing. At this point, we still don't have an application window. The CCC has not yet released that. What we do have right now is the social equity applicant certification portal. So any individuals or businesses who are seeking to be certified as a social equity applicant have the ability to apply for that through the commission's website. They're currently accepting those applications now, but that application period closes at the end of the month. So if you are trying to be certified as a social equity applicant, I certainly recommend applying for that now, because if you don't, you will have to be put into the lottery with the general applicants, and we certainly expect there to be a lot more general applicants than social equity or workers cooperative applicants, which would make the lottery process that much more competitive. But with the social equity applicant portal and process finishing at the end of this month, we expect the application window for retail licenses generally to be open within the next coming months. It could be October, could be a little bit later, November, December, but certainly we don't believe it'll be too much longer after the social equity certification period closes. Next slide, please. All right, so high level overview of top 5 items. If you are thinking to yourself, what do I need to do? What are the most important things I need to do to get ready for this? So you need an entity to actually apply. An important piece will actually be forming your entity and making sure it qualifies for the type of license that you're applying for. So usually an LLC or a corporation, depending on how you prefer it, and there are certainly some tax considerations to go into that. And then social equity status would need to be majority owned by the individual certified as a social equity applicant. And then there are very specific state-specific rules for the workers' cooperative. So when you're looking to form an entity, definitely important to think about what type of entity and whether it will allow you to qualify for the certain types of licenses that you might be interested in. Property control is a huge component. If you don't have a property, you can't get the zoning approvals you need, and you won't be able to submit a complete license application. So finding a property that's zoned correctly, it's not too close to schools, and you have a binding interest in that. So whether it's you actually own the property and have a deed to it, or a lease agreement with a landlord, that is certainly something that I would focus on sooner rather than later. Zoning approval, as we mentioned, our understanding is that final zoning approval from the local municipality is required in order to apply. We'll go through that process a little bit later on, but very important part of this application as well. Access to capital. This is certainly in a capital intensive business, highly regulated industry. So there's no minimum capital that you have to show, unlike in some other jurisdictions, but you do need to have a financial plan that will, convince the CCC that you have the financial resources to get up and running in a timely manner. And then the right team. So as I mentioned, you have to have majority ownership by Rhode Island residents, and you need a business plan that shows that you'll able to operate in a compliant manner. So putting together a team to be able to show that it will be a very important part of this. So top 5 action items, but there's certainly a lot more that'll go into it as well. Next slide, please. Okay, so very, very high level overview, some top 3 tips. Very important to understand what the rules are, what the requirements are, what you're not allowed to do, so that you can be efficient in your efforts and you don't go down a path that's actually ultimately not going to work out. I would certainly recommend starting now. I know we don't have an application window open yet, but these things take time. Forming your company, raising money, obtaining zoning approvals, locking down a property. These things take time, and you want to be ready to submit when the application window is available. So definitely is advisable to start sooner rather than later. And then very important to make sure you have a complete application. So everything you put together needs to be compliant with the application requirements, the regulations, the statute, any sort of instructions that are put out by the CCC when the time comes. Again, it's a hybrid lottery, so you need to have an application that will be deemed qualified, and then that will get you into the lottery. And after that, it's hoping the chips fall in the right way. Next slide, please. All right, so just quickly, there is a state setback and zoning approval requirement. So by statute and by regulation, your retail facility cannot be located within 500 feet of the property line of a pre-existing public or private school that has students in grades K through 12. So when you're doing your property search, very, very important that you make sure that your property is not too close to a school, and it can sometimes be difficult to ensure that. But it's a very important piece because this is not a requirement that can be waived or you can get a variance from. This is something that is absolutely required, and so very important to make sure you're not too close to schools. And then you'll see at the bottom here, I provided the exact language from the regulations about this local zoning approval. It really is sort of 3 components. One is evidence of full compliance with local zoning laws, so from a municipal zoning officer. So this is something that you would go to, the municipal building department or zoning enforcement officer, or it could vary from municipality to municipality, but you'll need some sort of a certificate or letter from them that states that your proposed facility is compliant with all of the local zoning rules. More significant than that is this requirement for having final zoning approval. So in certain municipalities, to be able to operate a retail cannabis business at a particular location, you'll need what's called a special use permit, which is granted by a zoning board of review. It's an involved process. Again, varies from municipality to municipality, but it does say that you need a final zoning approval, and this process can sometimes take a little bit of time to put together and go through the public hearing process. So definitely one of the requirements that you'll want to really start on right away. And then finally, a certification by a representative of the company that you comply with your applicable local zoning ordinances. So this is a unique part of this, that we don't often see this in every jurisdiction, especially where there's a lottery. But as we understand it right now, this is an important piece that you'll have to obtain in order to get into the lottery. Next slide, please. Okay, enough from me. I will now hand it over to Phil to get a little bit more into the local zoning and some of the property considerations. So take it away, Phil.
Great, thanks. Next slide, please. All right, so we're talking about the steps and the documentation needed for municipal approval. As David explained, in order to have a complete application at the state level, you have to show that you have your municipal approvals. So I'm just going to walk through, some of the considerations that go into gaining these municipal approvals. So the first thing is you've got to be within an appropriate zone within the municipality. So just the fact that that these retail stores may not be prohibited in the municipality that you want to operate in, it doesn't mean that you can do it anywhere in the municipality. All these towns, both for cannabis reasons and other commercial activity, have zones where some things are allowed, some things are not allowed. In the case here, in Rhode Island, there are some municipalities that will not allow any cannabis retail operations, and we'll go into that a little bit more later. But then, generally there's a zoning, outline that sort of tells you where is it appropriate within the municipality. A lot of municipalities, for example, won't let you have a retail store in a residential area, for obvious reasons, just like they might not allow any other retail operations in a residential area. And some will specifically try to put these types of retail stores in a commercial area or even an industrial area. So you've got to find out what the scheme is in the local municipality you're trying to move forward in. The next thing you want to look at is whether this is something in the municipality that's allowed by right or with a special use permit, okay? The preference would be if it's allowed by right. In other words, some communities will have a zone and say, in the residential area, this is allowed by right, meaning you can just do it. You don't need to apply for anything else at the municipal level to be able to do it. That's preferred because it saves you a lot of money, not having to go through a municipal process. Obviously there's no risk that you might not succeed in that municipal process. But there's not that many communities that will do that, although Providence, as David is going to talk to you about, actually is one that has areas where you can do this by right. Most of the communities are going to do it through what's called a special use permit, where you actually have to file an application, and I'll get into that in just a moment, what's required for a special use permit application. The next thing I'll just talk about quickly is local setbacks and dimensions. You're probably familiar, as David mentioned previously, that there's a 500-foot buffer from schools. But sometimes the local municipality has its own buffers. That may differ. There's a question as to whether they can do that, whether, for example, you can have a conflicting buffer with the state law. I don't think you want to go too far into arguing with the town. They're always going to think they have the right to say what can be where and how far it needs to be from various areas. But it is, when you're choosing a property, it is something you really want to be aware of, because it's just another obstacle that can get in your way if you're, in these types of, within the buffer from some type of a sensitive use. There are other dimensional issues with a property. Sometimes, there will be something that says a retail store, for example, has to be, have a more than 30-foot setback from the front yard, like from the road in the front or on the sides. Those are things that you need to be aware of, dimensional buffers, that can get in your way when you're trying to get a project approved at the municipal level. Now I'm going to just hit application. So when you do have a special use permit requirement in a town, generally there's going to be an application that has to be filed, often with some kind of a zoning review board within the town. And what you're basically trying to prove is that this type of a use is harmonious with the surrounding community where you're proposing to put it in, okay? Every application is different. There's no standard application form that all the municipalities use. They all have different requirements and different forms. But, you know, a lot of them can get very extensive. You know, they can be significant, require significant narratives describing, you know, all of the different operations, you know, security procedures, you know, operational procedures, waste disposal, all sorts of very technical issues that can be required. And, you know, certainly we've done quite a bit of this, and you know, we do have, you know, quite a few sort of templates that we use, but every one of those is going to need to be tailored to the requirements of the community, as well as the state requirements in Rhode Island. Next thing that's very common when you're filing an application for a special use permit: site plans and floor plans. You know, the site plans, they generally want to see this because it's sort of it's a good way to show how this fits into the community. It's going to show you some of the other uses that are surrounding your marijuana use. You know, you're often going to put some, you know, you're going to show them what your parking situation is. How many parking spaces do you have? You're going to show them access and egress points from your facility. Things like, you know, what kind of lighting that you're going to have at the facility. That's obviously, you know, something that they want to be careful about and make sure these facilities are well lit. Landscaping is often something that is required in these types of site plans. And, you know, you'll even see requirements of traffic studies to be provided with a site plan that just give a sense of, you know, how much traffic are you going to see and how's it going to flow, you know, on the site itself. So these are the types of things you're probably going to need to bring a civil engineer on in order to help you with site plans, traffic studies, and things of that nature. A lot of the municipalities will also require a floor plan. They want to see what the sort of the operational flow of the business is. Usually, you know, for example, you know, the front door opens into what we call a man trap or a sally port. They want to see that. They want to see where your limited access areas are that only certain credentialed people within the facility itself, the employees, can go. They may want to see a security overlay plan that shows where the cameras are, where the alarm systems are, that sort of thing. So oftentimes you'll have to be speaking to an architect in order to do that. You may even require a security company to provide a security overlay. Next slide, please. Okay. So just wanted to quickly, you know, go over certain municipalities that are going to be prohibiting retail stores. You know, Smithfield, Situate, East Greenwich, Barrington, Jamestown, Lil Compton, they have all determined they'll be prohibiting these types of stores. Obviously, you want to avoid these places when you're looking, you know, to locate. But you really need to sort of go beyond that when you're searching for a property in a municipality. Obviously, when that zoning, you know, those zoning issues I was just talking about, you know, there will be times where they will put, there will be towns that will try to put these retailers in, for example, industrial areas. That was very popular in Massachusetts early on. And, you know, you got to be careful with that because industrial areas tend to be less traveled. They're not necessarily viable for this type of a business. And you certainly, you know, you don't want to look at this like, well, my only choice is to go to an industrial area. That might work, okay, you know, depending upon where your competition is or how far off the beaten path it is, but it's something to be careful about. You need to take that into consideration when you're looking. Also mention here, you know, in terms of, you know, the zoning, I mentioned that there may be other local buffers other than just the you know, the prohibition of locating too close to schools. Some municipalities, you know, have a setback from churches or playgrounds or daycares or dance studios, all sorts of things that these municipalities do, you know, to try and keep a business like this away from sensitive uses. Again, they may not be required buffers, but it is something to be aware of. when you're choosing a site, even if there isn't an actual setback requirement. I've seen, municipalities that kind of say, well, we just think you're too close to these particular things and we're not comfortable with it. Whether that's within their power or not to say that is another question. But like I said, it creates an obstacle, and you really do want to avoid obstacles here. The other thing to be, mindful of, even if you are looking at a particular site and love the site, but at the local, let's say they have a setback of 500 feet from a church, and you are at 497 feet. There is a procedure called a variance in a lot of municipalities where you can attempt to sort of get an exception to that setback. It can be complicated. It can be time consuming. They're not always easy to get, depends on the community, but it is something to be aware of, that it's out there and it's possible. Next slide, please. All right, obtaining site control. So, the state application, as we've mentioned to you, is going to require you to lock up a property in order to use that property to apply with. And it's not always easy to find these. I've already mentioned zoning and how difficult it can be to find an appropriate property due to zoning. But bear in mind, there are other obstacles that can get in your way. For example, not every landlord wants to do business with a cannabis company. That gets in the way. Also, I would mention, even if you do find a landlord that wants to work with you, we've seen situations where you get to, the situation where you sign a lease, you're going forward, and then all of a sudden the landlord finds out that they have a mortgage on the property, and their bank has gotten wind of it and said, well, there's a prohibition in your mortgage that says that you can't, rent to a business that is federally illegal. So, that's just finding that site can be very difficult. And then, let's remember, what's going on here is you've got to lock this property up for a while you try to get these approvals. So the cost can start to get, prohibitive. So what you really want to do, is try to seek deals with, for example, a landlord in a lease situation where, you'll pay some kind of a holding fee so that they'll keep that property open for you while you're going through the approval process. But you try to minimize the cost, and you sort of coordinate that with the licensing process so that, you minimize your costs while you're seeking it. Next slide, please. Oh, no, I'm sorry. I'll go back to that one, the prior one. Apologies. Leasing or purchasing. This is a decision you got to make at the outset, whether you want to own your property or you want to lease it. There's obvious advantages to both, disadvantages to both. You own your property, you're going to be putting significant money into this property, both for security, the build out of the property. That's all generally something that's going to be your responsibility. And to do that and then have your lease expire and you don't really maintain any benefit from it, that's a hard pill to swallow for a lot of people. So there are people for that reason that like to, to own the property. On the downside of owning is, this is a capital intensive industry. You got to put a lot of money up to both get your approvals, get your state license, and build out. You may not want to add into that the high cost of trying to actually purchase a property, especially given what properties can cost here in the Northeast. So that might discourage you from buying. Switch over to sort of the lease situation. Obviously you don't have that situation where you have to put up the money to buy. You essentially, on some level, you're paying over time for the right to use that property. On the other hand, you're also buying into a new relationship with a landlord, and that can be difficult. We've had clients that have had very difficult landlords that just, don't really, want to sort of be comfortable and work with you. You sign the lease, and then every single time something happens at the property, or they can come up with some picky little item in the lease, which a lot of landlords would ignore, and they don't. And then you're sort of stuck with that person over a period of time. So that actually militates in favor of maybe buying a property and not having to deal with the headaches that can come. A lot of these issues, whether to lease, whether to purchase, they'll also depend upon some tax issues, and we certainly recommend having a good accountant to get through that as well. Next slide, please. All right. So once you decide, excuse me, that you want to lock up a property, doesn't matter if you're planning on leasing, whether you're planning on purchasing, either way, there's two ways to do it, okay? One is to actually sign a purchase and sale agreement, if that's your way of doing it, to actually buy, or sign a full lease if you're looking to lease. The other is to do a lesser step called a letter of intent, usually with that has within it an option to purchase if you get your approvals. So remember, your ability to go forward here is all contingent upon getting your municipal approvals and winning the lottery. So, a lot of people would decide, I really don't want to go through the expense of negotiating a full purchase and sale agreement or a full lease at the beginning right now. I mean, that's just, that can be time consuming, resources, legal expenses, etc. I really don't want to do that when I don't know whether I'll actually ever get to the point where I want to exercise the lease or actually go through with the purchase. And so they prefer to do a letter of intent that usually, lays out some of the basic terms, in the case of, a purchase and sale agreement, it's going to be the sales price, and, the closing date and things like that. In the case of a lease, the rent, the term, whether there are any extensions or renewals available, deposits, that sort of thing. And you lay those out, and then if and when you actually get approved, both municipally and at the lottery, then later on you will sign the actual lease or the purchase and sale agreement and go forward at that time. That's when you'll incur the expense because you're good to go on the local and state side. That's often we have a lot of clients that do that. On the other hand, especially in the lease situation, if you only have a letter of intent with sort of the basic terms, once you win the lottery and you're ready to go forward, the landlord kind of has a little bit of leverage on you, and they know this person spent a lot of money trying to go forward, and do they really? I can sort of stick it to them a little bit and try to get better lease terms on some of the lesser issues, but that can be very significant in a landlord-tenant relationship. So you got to decide, early on whether you want to do, in terms of an LOI or the actual, operative documents. Next slide, please. Just a couple of lease considerations if that's the route you choose to go. You certainly want to, obviously, local zoning compliance is a major issue that you want to figure out. I've already talked about that quite a bit. But then, there's the basic terms, rent, the term of the lease, deposits. But then there's some lesser issues too, who's responsible for maintenance, taxes, insurance. Those are big issues as well, that have to be considered. Just another piece that's important is parking with these leases. A lot of the times the local municipal zoning requirement has a parking requirement. It may say something along the lines of 2 parking spaces for every 500 square feet of commercial space, for example. It differs in different places. But you want to make sure that when you do your lease, you've got a provision in there that talks about how much parking do you get. Or in the case of sort of where you're one of many tenants in a space and it's shared parking, access to how much access to parking spaces do you get in that situation as well, because you're going to need it for your municipal zone and your special use permit in those cases. Also, there's things like termination rights in the lease. Obviously, if you do go the lease route and you don't get your approvals, you're going to want to be able to terminate. Or, for example, maybe you will get a municipal approval, but it'll be with conditions that are so harsh, requiring you to make certain additions to the property such that you want to have a termination right for that as well. So that's something to think about. Then finally, something like, assignments and subletting. Sometimes, You don't necessarily want the licensed entity to be the party that holds the lease from the landlord. Some clients like to put a real estate holding company in between the landlord and the licensed entity. We can talk to you about that, but it is something at the time of the lease to think about. David, I think we go back to you now.
All right. Thanks, Phil. Can you still hear me?
Yes.
Okay, excellent. All right, so just as an example, we wanted to provide just an idea of what the zoning requires in the city of Providence. So next slide, please. So these details are taken directly from the zoning ordinance in the city of Providence. Every municipality has its own, zoning bylaw or zoning ordinance that should set forth, assuming they've adopted zoning specific for cannabis businesses, they should set forth the rules on where they can be and how close they can be and some other types of requirements. So we thought it'd be helpful just give you a little taste of what it's like in Providence. So the city of Providence has its own setback that in some ways matches the state's 500-foot buffer from schools, but it also throws in a 500-foot buffer from other cannabis retailers. So that's not something that's in the state rules, but you certainly would want to be aware of it because if you do find a facility that's too close to another retailer, you won't ultimately get the zoning approvals that you need. Also just wanted to point out how that 500-foot distance is measured. So it specifies in the zoning that it's from the property line to the property line, and that can make a big difference. And as we've seen in New York recently, you want to make sure that you get that right and that it's interpreted correctly and that you measure it exactly right because it could be a problem if you think you're set, and then for some reason it's determined that when you measure it in a different way, you're too close to the buffer. So very important to be aware of that. And sometimes it may take contracting with a civil engineer or a professional land surveyor just to make sure you're measured exactly right. Zoning districts are super important. So every zoning ordinance should have a table of uses that sort of sets forth every type of use that's allowed in that municipality and what zoning districts it's allowed in. So just like how the state is divided up into geographic zones, every part of a municipality is divided up into zoning districts. Some are residential, some are commercial, some are industrial. But in Providence, cannabis retails are explicitly allowed in these zoning districts, commercial 3, D1, M1, M2. And depending on where you are, as Phil mentioned, you may need a special use permit or it may be allowed by right, in which case you would not need any sort of local zoning approval. So very important to realize, where your property is, if it's in the right zone, and what types of permits may or may not be required. Also very interesting, this is a bit of a unique thing, is that Providence has made it so that certain types of applicants, the zoning districts are different. So if you're a social equity applicant or a workers' cooperative applicant, you may be able to locate in a zoning district by right and not have to obtain a special use permit that a general applicant might have. So very important to make sure that you're in the right zone and you know what the municipal approvals are. Also, as Phil mentioned, parking is a particular issue of concern especially for retail facilities. And the city of Providence has very specific minimum parking requirements, not just for vehicles, but also for bicycles. So important to make sure you have a plan for that and that your property will actually be compliant with those rules. And in Providence, the zoning board of review is the permit granting authority. So that is the municipal body that makes final decisions on special use permit applications. And they will hold a public hearing and members of the public will be invited and, abutters and other people who may have may be impacted by the use will all be invited to come to the public hearing. And that's certainly after you submit an application for your special use permit, which requires, as Phil mentioned, a variety of documents and plans. So this is a very specific process that you'll want to follow as part of your local zoning approval process. And every municipality does it a little bit differently. So You'll want to just make sure that you speak with the right municipal officials and understand exactly what the different requirements are before you go down that road, because it does take some time and some money to navigate that process, but you won't be able to go too far unless you successfully complete this process. Next slide, please. I think that's it. Oh, social equity certification, excuse me. So just wanted to finish up with the social equity certification. So as I mentioned, we're currently in the open window for people to apply for the social equity certification status. It's a online application and it's live through September 29th. There are a variety of benefits that attach to social equity status, not just having certain licenses reserved for social equity, but there could be things like priorities for licensing review or other technical assistance that you can receive, reduced fees for your license fee. So it is a valuable status if you're able to obtain it. And I recommend certainly exploring it. There are certain criteria and eligibility requirements that you have to meet in order to be certified. But I certainly would recommend that if you're interested in obtaining that status, that you apply for it sooner rather than later, because there is a limited window and you may not have another opportunity to apply for that status in the future. Next slide, please. So as I mentioned, there's a process that's set forth on the commission website. So there's an initial form called an interest form that would need to be submitted by September 24th. And then you'll be given a link to access the certification portal. And that's where you can finish the rest of your certification application. And again, you have until September 29th to do that. So don't want to miss that window if this is something you're interested in applying for. And I believe that's it. Next slide. Thanks everyone. And now I think we have just a couple more minutes and we can open it up to some questions. If you've put them in the Q&A, I believe we have a couple that I'll just run through here. So first question was about the manufacturing license. So there is a separate standalone adult use product manufacturing license that is available. Again, just like with the retail, you can only apply for it during open application windows, and we do not have any information at this time about when that application window will open. But the process, I believe, will be very similar to the retail license application, but you'll just have to wait until the CCC actually sets up that application process. Another question is when the moratorium went into effect. So the moratorium is statutory. It's in the Rhode Island Cannabis Act, which went into effect in May of 2022. So it's been a couple years, and I believe that the moratorium will be in place for 2 years after the regulations were finalized. So the regulations were finalized by the CCC and went into effect this spring. So it'll be 2 years from a few months ago for when they may be willing to issue new cultivator licenses. Next question is about eligibility requirements for social equity. So the regulations and the statutes set forth a variety of criteria that you could potentially use for obtaining that equity status. It's a sort of a range, and it depends on how you can meet it. So for example, one of them is having 51% ownership by individuals who have a prior arrest or conviction for a cannabis related offense, or be a family member of someone who's had a cannabis related arrest or conviction. Another criteria that could potentially work is demonstrating past experience in economic empowerment in certain areas of disproportionate impact, which are regions of the state that have been identified as having had a history of disproportionate arrests for cannabis. It was something, over the years where prohibition has resulted in a variety and numerous arrests there. So I certainly recommend that you take a close look at the eligibility criteria. Certainly reach out and we can try to help you navigate that. But you know, if you think you would apply, you would need to submit the application through the portal and have supporting documentation, and then the CCC and its third-party vendor will review it, and then assuming that you meet the criteria, they'll give you that status will be issued to you. All right, next question is the lottery free? So there is an application fee that I mentioned. For the retail license, it's $7,500 just to submit your application. And again, if your application is deemed qualified, you'll be entered into the lottery. So there is a fee for most applicants, but if you are a social equity applicant, that fee is waived. So I guess you could say for social equity applicants, the lottery is free, although it certainly would take some expense to get your application together to submit a complete one. Question about property. So property, as Phil mentioned, is required. And not just having a binding interest in a property, whether you have an LOI or a deed or a purchase and sale or a lease agreement, not just being able to provide documentation confirming that, but we also mentioned that having zoning approvals is also required. So you certainly would not be able to obtain any final zoning approvals unless you have a property that is located in an appropriate zoning district and is approved for that retail cannabis use by the permit granting authority. Question about majority ownership, how long the entity needs to be majority owned by a Rhode Island resident. That I do not believe I have seen any requirements for. I know in some jurisdictions they want you to prove that you've been a resident for a certain number of years. I don't believe, I'd have to double check on this. Certainly happy to chat about it afterwards, but I am not aware, and I'd have to go back and check just to confirm if there's any sort of duration of how long you need to have been a resident of Rhode Island to qualify for that residency for the majority ownership. You mentioned there's a hybrid application process where qualified applicants a lottery scoring component. So I am not aware of any sort of scoring component for your application and again, we don't have the application form or the instructions at this time. It may set forth something like that, but just from reading the regulatory requirements, it's that the CCC would need to review your application and deem it to be qualified. So it's a little bit subjective. I'm not aware of any sort of breakdown of any kind of rubric or scoring metric that you would need to achieve in order to be into the lottery. But once we get additional information about the actual application process, we may have a better idea on that. But even without any sort of scoring process, you certainly would want to just put forth the best application that you can. Again, making sure it's fully compliant with the regulatory requirements. And as polished as possible, so that you have a better chance of actually being deemed qualified. Question about one more question here about the lottery application fees are refundable. My understanding, and I believe the regs clarify that it is a non-refundable application fee. So you have to pay that fee, assuming you're a general applicant, in order to submit your application. But if you don't win the lottery, you will not be refunded that fee. And I guess one last question about when's the lottery taking place. We don't know that at this time. I do know that the regulations lay out a process for how they will do it. It will certainly be a scheduled time and place. And if I remember from previous licensing rounds, representatives of the companies are required to attend an actual in-person lottery where they will do the selection in person. So sort of a unique type of thing here, but we don't know at this time when the lottery is taking place. I think it will depend on how long the licensing window is, how long it will take the CCC to deem applications qualified, and sort of set it up and make sure it's all set for the different geographic zones and license types. So I think at this point we're out of time. This slide here shows our names and our email addresses. You can also find us on our firm website, Vicente LLP. But feel free to reach out if you want to discuss further or need assistance or have questions. Phil and I would be happy to discuss with you and to give
David,
Phil any yeah, go ahead, Phil.
you want to mention the in-person event that
Yes.
we're having?
Yes, thank you, Phil. So we are having an in-person event on September 17th in Providence at a restaurant, and we'll be providing a panel discussion on covering some of the same topics we covered here, as well as having a sort of networking opportunity to allow people to meet Rhode Island residents if they're out of state, or connect with investors or other sort of third-party service providers who can help with the application. So we recommend checking that out. You should be receiving some information about that upcoming event. And again, that is on September 17th. And I think we're out of time. So thank you, Phil, for all of your knowledge. Thank you, everyone, for coming, and we really appreciate it. And again, feel free to reach out. Things are moving fast, so you definitely will want to get going if you really want to submit an application. So thank you so much.